ThinkPod, an initiative by ANM Global.
Hello and welcome to ANM ThinkPod, an initiative by our law firm ANM Global, where we discuss legal issues and topics of current relevance and discussion. So today we have assembled to discuss a very important topic, that is trademark infringement vis-a-vis use as a keyword or a meta tag. I have here with me Mr. Rahul Dhote, who is the partner and IP head of our law firm. So welcome aboard, Rahul.
Thank you, Shwetank. Thank you. This is a very interesting discussion. Thank you for having me on the show.
So, Rahul, before we delve deeper into the details of the topic today, can you explain us briefly or simplify for us the concept of this keyword or meta tag, and what is the difference between the two in terms of functionality on internet?
Very important topic, Shwetank. So this is especially relevant in the day and age of the internet, which is at a pretty advanced stage. If you see the competition dynamics today, many of the products are selling online, than offline. Just to give an example, there are new products being introduced in quick commerce. Having not having any brick and mortar store, they are able to generate more than hundreds of crores just by selling on quick commerce app in a year. So you can see the potential that is happening on the in the online world. Because of this, the digital market players and the marketing strategists, they are coming up with novel ways of marketing the products and creating online visibility of the products. And so are the search engines. So there are various search engines like Google, there is Yahoo, there is Microsoft. All these search engines are also trying to optimize revenue by commercially exploiting this aspect to the best possible way. So coming back to the difference and the concept of AdWords and meta tag, both are basically tools for search engine optimization. Okay. Where an attempt is made by the user to search a particular ad, and the entire strategy revolves around whose product comes first. Okay, when it comes in the search result page, search result page is SERP. That's there, so that's basically the search engine result page
Interface. That
correct.
Yes.
So it's always the attempt is to come first, so that there is traffic diversion, and you also stay ahead of the competition and you are not left out. So coming to keywords, first I'll take the keywords and I'll try to break it down. Okay, so keywords, just to give an example about Google, because Google has this keyword policy, which is the AdWord program, basically.
Yes.
They have named it as a AdWord program. So it is their proprietary platform where basically if a product wants or the advertiser wants a particular keyword or their product to be advertised on the search result page, the Google has the AdWord platform where such keywords can be bid. So there is a bidding process. Okay, where once whoever the advertiser wants to advertise it. So for example, if there is Make My Trip, okay, just to give an example, and they want to advertise or they want their product to be also visible when somebody searches for booking.com. Okay, so what they will do is, if booking.com is available on the AdWord Key Planner platform, they subscribe to it and they bid for it. Okay, and whoever is the highest bidder, results come up at the top. Okay, so this is how the bidding process happened, and this is called the AdWord, where you can say that it is a inorganic result, not an organic result.
Right.
Okay, so let me further break it down. So if you see a sponsored link, okay, it's always the AdWord when you bid to the process, and when your result comes up at the top, you see a sponsored link or
Yes.
ad, where it's always written sponsored link or the ad. So there is a ad title where there is, for example, buy running shoes online. Okay, that can be the ad title. Okay, then there can be a ad text to it. Okay, just below that that portion covers that discover the latest running shoes kind of a thing. Okay, just to give an example,
Right.
hypothetical example. And then there is a URL. So there is a ad title, then there is a ad text, and then there is a URL. All these three are the components of a sponsored link, where once you bid for that particular keyword, then your result or sponsored link comes at the top. Okay, so that is the keyword, okay, or the ad word that I'm talking about. Secondly, coming to the aspect of meta tagging. Meta tagging is nothing but keywords embedded in the code of a website. So if you see, whenever you inspect a website, you will see source code of the website. So these keywords are embedded, or the competitor keywords are embedded by the advertiser or the owner of the website in its source code. So it is embedded in the source code, and whenever a relevant search is made for Make My Trip or Booking.com, for example, if a competitor has that particular keyword in its source code, that based on a lot of other features like the quality of the coding that is done and the keywords that is used, the inorganic result also comes. So one is the organic result comes. So one is the organic result, which is which can be done by use of meta tag, and the second is an inorganic result, which is
because it comes as a sponsored link or an advertised link.
So that's the basic difference. In fact, meta tag was defined for the first time in Shaadi.com case by Bombay High Court by Justice Patel in People Interactive, that is the Shaadi.com versus 𝐀𝐍𝐌. So that was the case where the defendant was using Shaadi.com and also using Shaadi.com as a meta tag in its source code. So Justice Patel defined meta tag as being special lines of code which are embedded in the source code. So that's the words that were used to define meta tagging. And because there was diversion of traffic, so Shaadi.com was diverting the traffic from Shaadi.com to their website. There was ample amount of confusion that was happening. The court came to a conclusion that this is nothing but hijacking plaintiff's reputation and goodwill and riding upon or piggybacking upon the goodwill and reputation of the plaintiff, and that's why this is an infringement. So there were various aspects. This was also using a similar trademark, because Shaadi.com as a mark was registered, and it had substantial goodwill and reputation. So it was Shaadi.com is also a similar mark and a domain name, which is again infringement as per section 29 of the Act. And also because it was using this as a meta tag, okay, it was also infringement in terms of advertising, which is again covered by section 29 subsection 6. So basis this, the court came to a conclusion that this is an infringement. So yeah, just to sum up, it's a piece of HTML code that provides information about a web page to search engines. So that's meta tag, and primarily used for improving SEO, that is search engine optimization, that is the usage. And it's again an organic tool, okay, which shows organic results vis-a-vis the AdWords, which is an inorganic tool, which is used to which is used as a sponsored link where you have to bid and it is commercialized. Okay, so here in meta tag you don't have to pay, but both are used for indexing purposes. Both are used for how the results should be operated and how the viewer should see the results.
Thank you, Rahul. Thank you for breaking this down and explaining it in a simplified manner. So, like you mentioned about the differences between keyword and meta tagging, recently there has been an increasing discussion and cases in court fighting in a close fight between competitors, where the court's infringement claim, particularly with respect to keyword and meta tagging issues. So, can you take us through the jurisprudence or how the cases have evolved and what the courts have really held in terms of infringement with regard to these forms of usage?
Certainly, Shwetank. So this issue was adjudicated in multiple orders in the past. Both meta tag as well as AdWord has been discussed. But I'll straight away come to the Delhi High Court case, of DRS versus Google. There was a single judge decision in 2017, and then there was a decision in 2023 by the DB. It basically encapsulates the entire law of meta tag and adword as it stands now in the present moment. So the issue involved was whether providing a trademark of a owner as a keyword to a third party, would that amount to an infringement or not. So defendant here was Google. Facts of the case where the plaintiff was Agrawal Packers and Movers. Okay, so it's a logistical company. Whenever the viewer used to type Agrawal Packers and Movers, a lot of results used to come, including the results of similar looking marks, which were trying to ride upon the goodwill and reputation of plaintiff, and they were already injuncted by the plaintiff. Still they were showing in the results. So there was nowhere to go for the plaintiff. So the plaintiff alleged that this is in fact the use of that trademark as adword and putting it in the bidding process by way of key planner and having a third party advertiser using their keyword or their trademark to advertise their product, or to divert the traffic from plaintiff to some other third party advertiser. That amounts to blackmailing, or that is also in the nature of blackmailing, because it was alleged that by doing so, Google is also asking me to bid for a higher value. So it is in the nature of blackmailing. So this is one of the allegations put by the plaintiff, and such use by the plaintiff, they argued, is causing confusion regarding the source of the particular product or services, and also leading to diversion of the web traffic. So plaintiff also filed various affidavits. One of the affidavit is how the public at large is getting confused, how the loss is being coming to them, because they are under the apprehension that this is a plaintiff product and services, they are subscribing to some other services, and there was damage of goods or whatever. So these such affidavits were also filed. Another interesting aspect is there was also a discussion of intermediary liability, because there was an issue of intermediary involved. So the plaintiff was saying that Google cannot claim a safe harbor provision or the exception under section 79 of the IT Act. Yes. Which a defense was taken by Google, that they are merely providing the keyword, they are not actually doing the infringement. The third party advertiser, based on the search or the keyword planner, they are selecting it and they are putting the sponsored link on the SERP, that is search result of the Google. So because of this, there is no infringement, and they should be able to use the exemption that is accorded under the section 710 of the IT Act, to which the court held that Google cannot be a mere spectator, because it is a active participant. It is providing the word, it is using the word, using the registered marks, and trying to monetize it. It's not like it is giving for free. There is a bidding process that is happening, because of which they cannot claim an exemption under section 79. So that is what was held by the single judge. So other key observations of the court were section 29(6) was discussed in a detailed manner. So section 29(6) basically deals with infringement by way of advertising. So here the court said that if you are using the keyword in terms of advertising, and the use of the keyword as a mark amounts to use under section 29(6). So here the Google's advertising platform qualified as use because it impacted the visibility of the search results and directed consumers' attention to specific advertisers. That was the what the court held. Google did take a defense under section 2 of the Trademarks Act, where basically if you see section 2 subsection 2 again, it talks about advertising in the sense of print and visual medium. So the court rejected that, and they drew an analogy to meta tags, that in meta tag also even if it is invisible, if it diverts the traffic, it still amounts to infringement. Yes. So the court held that such usage in terms of 29(6) in advertising amounts to infringement. So they drew a presumption that use of that particular trademark in advertising amounts to infringement. There was a presumption that it amounts to infringement and also amounts to confusion. When it comes to the next top, there were various other submissions that were made. The court, like I said, drew a reference to the meta tags and the orders passed in the meta tag cases. Coming to confusion aspect, which was discussed widely, the court said that such use is, again I said that it is assumed that it causes confusion. There was a discussion that discussion about the classification of the Indian consumers. So the Google said that the Indian consumers were literate and semi-literate. Okay, so they understand the difference between a sponsored link or an inorganic link or an organic link, and they know what they are searching for. So that's why there is no infringement, because they can distinguish their results. So the presumption is not applicable, to which the court denied that the consumer test applicable in UK, because Google cited a lot of cases in international jurisdictions, including UK. The court said that that analogy cannot be applied to India, because in India, average intelligence and imperfect recollection analogy is triggered, because of which such usage of a keyword in advertising amounts to infringement. It is presumed that there is an infringement to that aspect. Third party advertiser of the trademark owner's mark, then then Google will have to take it down. So the investigation aspect is basically the operative portion, and what we discussed was the observations. Right. And these observations basically would be applicable to other cases where such kind of facts are presented before the court. Yeah.
Interesting order. So this case went also to the division bench of Delhi High Court.
Yeah, certainly. So this was quite hotly contested matter in the division bench as well. So the court, just to set a pretext, the court did not disturb the operative portion. Still, the Google has to investigate and take action. But certain observations were made which were not aligned to the single judge decision in this case. So the court noted the competing interests at play here. So on one hand, the owner of the trademark faced the issue of its business being diverted to its competitors. On the other hand, Google was operating a proprietor service and want to operate it in a manner it desires, so long it does not, commit any unlawful act. So these were the competing interests at play. Balancing this, the court rejected the contention that the Trademarks Act grants a proprietor of the trademark monopoly over the SERP, that is the search results page. Right. You cannot claim a monopoly just because you have a trademark. That does not mean that you have a monopoly on the entire search results. Okay, right. So that is one of the findings that the court said. Secondly, a very important observation by the court, or decision by the court, you can say, is section 29(6). The court said that the use of the keyword under section 29(6) as by the third party advertiser amounts to use. Okay. I'm not saying, the court said that we are not saying that it does not amount to use. It certainly amounts to use, but it does not amount to infringement just because it amounts to use.
Right.
So you have to show, if it's an infringement, that the use of the trademark as keyword is amounting to some confusion, or there is an unfair advantage, or there is some dilution happening. Okay, so confusion aspect is basically the essential part that the plaintiff will have to prove. Just because the trademark is used as a keyword in an invisible form does not mean that it amounts to infringement. So, quote unquote, what the court said is use of trademark as keyword absent any confusion, unfair advantage, dilution of the goodwill of the trademark is not an infringement.
Right. It is more like a real life example of a brick mortar shop where competing products are kept. Similarly, Correct. On the Google interface, the Correct. Products are shown.
Correct.
So it Correct. Makes sense also that per se it cannot be said to be an infringement.
Correct. But there was a distinguishing aspect to this. Okay, so the court clearly distinguished section 29(1) and section 29(6). Okay, so the court said that the trademark used by the advertiser, okay, which is the use of the mark by the advertiser under section 29(6), okay, is different than the use of a mark as a trademark in the trademarky sense under section 29(1). So just to give an example, again coming to Shadi.com or second Shadi.com, there are various other cases. There is a infringement that is happening, okay, because it's using a very similar mark to Shadi.com, okay, and there is also diversion of the traffic here, okay. So section 29(1) would be triggered in this case, vis-a-vis if there is a totally unrelated mark which there is no confusion, okay, then that is a use by the advertiser in the advertising sense. So there is a clear distinction. So if there is a use of a mark in the advertising sense, okay, for infringement you have to show confusion,
Right.
okay, and if you have to gather the facts and put it under the infringement aspect of or the infringement bracket of section 29(1), you have to show that there is a deceptive similarity and it is similar to goods. So it has to be used as a mark in 29, where here it is not that threshold that is met, because here it's very simple. Like you said, brick and mortar stores, if I have a Nike store and somebody comes up with Adidas store side by side, obviously it is fair. It's fair competition. Nobody can stop it. Right. Okay. I know as a consumer clearly distinguishing between the two brands. If I have to go here, I'll go here. If I have to go there, I'll go there. Okay. Likewise, if I buy a particular product, a tomato ketchup of company A, as soon as I buy that product, there is a discount that is triggered from company B. That's also fair.
Right.
Okay. So holdings close to each other. If you see in travel, you see competitors holdings close to each other. All these, if we apply in the online world, okay, as per this order, it is fair competition. You cannot just stop it.
Sure. This was rather complex than simple, I would say. But I think great, the division bench order pretty much sums up the legal position on this issue. And but we have seen many other cases. So what are these cases and how the courts have kind of aligned with this division bench's order or differed with it? How has the jurisprudence evolved further?
So the jurisprudence was slightly different earlier, okay, so because these observations are latest observation, there were many cases earlier which were adjudicated by various courts. So just to give an example, there was a 2010 case of 𝐀𝐍𝐌 Info Private Limited versus Google, where Shadi and Jeevan Sathi were also made parties. So basically the plaintiff here was the proprietor of Bharat Matrimony, Tamil Matrimony, Bengali Matrimony, all these sites. And whenever these words were typed, the competitor website, that is Shadi.com and JeevanShadi.com, used to come up. So the plaintiff alleged that this amounts to infringement because there is use of the keyword. And there was a bidding process that third-party advertiser, that is Shadi.com and JeevanShadi.com, subscribed to, and because of which the competitor results were displayed. So this, according to single judge, initially the single judge granted an ex parte injunction. Later on, the injunction was vacated, and the court directed Google to adhere to its trademark policy, that is protecting the a registered trademark by ensuring that others do not use such registered trademark. So initially the injunction was granted, and later on, so just to just one of the observation that the case had was initially in 2010, when the matter was before the single judge, the Google had a policy that they will investigate upon complaints of the infringement, both of the keywords as well as of the ad text, ad URLs and ad title. Okay, the policy was later on changed after the DB order. That
in DRS matter.
It was recorded in the DRS matter, but the policy was changed after the DB order in 2013 in 𝐀𝐍𝐌.
Okay.
where they changed the policy that they will not inspect the keyword infringement.
That possibly shows why these disputes are cropping up now and not earlier.
Correct. So, coming back to the case, another interesting aspect in the case was use of matrimony, Bharat, Tamil, Telugu as in a descriptive sense. So the court said that if it is used in a descriptive sense separately, it is not an infringement. It can be used. The keywords I'm saying about, talking about.
Sure. So this was
And then later on the policies which
So this was pre 2023 when the division bench of order came in DRS matter.
Correct.
So what happened post 2023?
So yes, DRS order was widely relied upon in later cases. So for example, there was a Policy Bazaar case where the plaintiff was the owner of Policy Bazaar and there were third party advertisers which were using Policy Bazaar. Earlier there was an injunction passed, but later on, relying upon the DRS case, they again came to this conclusion that this does, although this amounts to use, but this does not amount to infringement because there is no confusion happening. Both are very separate. The consumer knows that, so there is no actual confusion, or there was no proof of actual confusion that the plaintiff could prove. So earlier the injunctions which were granted in the cases were actually vacated, and because of the observation of DRS. Another important case or interesting case was Make My Trip. So Make My Trip versus Booking.com. It was hotly contested case again. Earlier the injunction was granted in this. Make My Trip filed a case against Booking.com because Booking.com was using MMT and Make My Trip and other words which were actually registered as a trademark by the Make My Trip owners. And because of that, the court held initially that this amounts to infringement, relying upon the meta tag orders and Shari.com, Shadi.com orders. But later on, the court, this was again re-adjudicated because Google filed an appeal and it was again re-adjudicated. In this, then, relying upon the DRS, the court clearly held that both are well-known marks. Make My Trip and Booking.com, people know the difference between the two, so there is no confusion. So though, again, coming back to the same analogy, though it amounts to use under section 29(6), it does not amount to infringement because there is no evidence of actual confusion that was provided.
Sure. I think this was at the interim stage, but tomorrow if the matter is tried and thereafter final hearing at
there might be a different result after that. Yes. Okay, so we'll have to only wait and watch because right now these are the observations and it stands today. Yes. And these are applied in various cases. They are presented before the court. There are so many advancement of the internet and technology that is happening. There might be some other issue of confusion that might happen and crop up, and the court might take some other view. So we'll have to wait for that. Yeah.
Sure.
Another interesting case was that I remember is Puma versus India Mart. So this is a very peculiar case. In this, India Mart was providing a drop-down menu for a person. If I'm the vendor and I want to sell my products on India Mart, there was a drop-down menu where I register my product. There in the drop-down menu, India Mart was providing Puma instead of shoes as a category. They were using the mark, and without verification, any person could randomly register themselves as Puma authorized dealer, or the genuineness of the goods are then presented by just clicking on the link. And the court said that amounted to infringement because you're actively providing a drop-down menu and you're using the mark as a category and allowing a third party to register in that category and selling the goods of the owner, which may be counterfeit. So that was one of the case where in a very peculiar circumstances, the court said that you're not an intermediary and this is a clear-cut case of infringement, where you are promoting the counterfeits being registered and selling the counterfeit goods.
Okay, so Google AdWord cases are somewhat clear that per se it does not amount to trademark infringement, but it will again depend upon facts to facts. If there is an actual confusion shown, then there might be a liability, because clearly the court has said that Section 79 defense is not available.
Correct.
Coming to the meta tag cases, because meta tag, you mentioned that it can be embedded in the source code and the search results will come organically.
Correct.
So how the courts have dealt with that? I'm sure it would be slightly on a different footing as compared to AdWord, where it is clearly shown that it is an sponsored link or an advertised thing. So how has the court dealt with the meta tagging related trademark infringement cases?
So in meta tag, the observations were quite clear and the findings were quite clear in earlier cases, and there were many cases right from the earliest case that I can think of is in 2008. There was a Mattel versus 𝐀𝐍𝐌 𝐓𝐡𝐢𝐧𝐤𝐩𝐈 case, which Delhi High Court adjudicated upon in 2008, where the plaintiff claimed to be the owner of the trademark Scrabble, and in relation to board games, and the defendant had adopted a similar mark called Scrabulous, and this was used in as a meta tag in the website, and the court said that this amounts to an infringement. Court really the foundation of the observation there by the court is the use of keywords as meta tag in the source code clearly amounts to infringement. So there was no discussion about the confusion aspect or the initial confusion aspect or any other aspect. That was presumed that because of this there was diversion of traffic, and that amounted to infringement. Then there was an Amway case as well with Tata 1mg, where Tata was it was alleged that the defendant, that is Tata, that is 1mg, the medical app, the portal where you sell medical goods or medical supplies, was using meta tag of Amway, and that amounted to infringement. Again, the court dwelled into the issue. There were key observations that were laid down. The court observed that 1mg was using Amway's trademark in the meta tag, and that they applied the principle of initial interest confusion here, that there was diversion of traffic, and the consumer was for a moment confused about this, and was going to their app instead of Amway app. So that was proved, and that initial interest confusion was shown, and the court took a note of this, and the court with this observation inferred that there was bad faith on the part of 1mg for deliberately leveraging Amway's trademark to attract consumers. So this is one of the cases that I can think of. It does reinforce the fact that trademark in meta tag without authorization constitutes infringement.
Interesting, Rahul. Thank you very much for taking us through these judicial pronouncements. I think all the judgments combined, the result, the takeaway would be that in case of meta tag, the courts have been rather strict, and liability for infringement has been upheld. But in cases of keyword, the courts have clearly made it clear that per se it does not amount to trademark infringement. But tomorrow, if the plaintiff is able to show that there is confusion caused and there is losses suffered by the plaintiff, then there can be a risk.
So the principles in both meta tag cases separately and AdWord cases separately, the principle and the application of law as per the observation recorded in DRS would be applicable. Now, after the DRS order, if the advertiser is only using the keywords and meta tag, he will have to show confusion and deception that is happening. It's not that merely by using meta tag the court will come to a conclusion that this is infringement. Yes. This is just the authorities that were passed before the DRS order. Right. But after DRS order, all this would change, and the applicability of law is slightly changed. And now, in both the cases, you will have to show all this tarnishment, dilution, and actual confusion that is happening, because both are invisible form of usage. So actual confusion is the threshold, which the court, it depends upon the facts of every case. Right. I tried to give an example of what exactly can be confusion, but that depends. It can be dynamic with dynamic cases.
Right, and there are cases, we have seen cases where the parties have somewhat agreed amongst themselves that okay, you will not use my keyword and I will not use my keyword. So I think I will not use your keyword. I think that shows that the parties are aware of the risk.
Yeah.
What are these cases, as in what transpired?
So, yes, I mean, obviously, if parties want to avoid all this litigation, they are taking cautious approach. Okay, so a few cases that I can remember is Urban Clap versus No Broker. Both the parties said that I will not use your mark as advert, and the other side also agreed to that. And cases were settled. They were Class 24 versus Ola also. They also came to a consensus that they will not use each other's mark as a meta tag also and as an advert also, because ultimately everybody wants fair competition. Both have their own marks, both have their own goodwill and reputation. They would try to capitalize on that rather than capitalizing upon the competitor's goodwill and reputation. So what I feel is that there has to be a cautious approach. Okay, there has to be a marketing strategy where you avoid all these disputes. Yeah.
Right, Rahul. That brings to the my last question for this episode is that what will be the key recommendations or takeaways that you will suggest?
So for the business owners and for the trademark owners, basically you avoid unauthorized usage of the mark. If it is causing some kind of confusion, please don't go towards it, because ultimately it will result in litigation, and the amount of money that is spent in building a brand that in some way gets tarnished. So avoid that, because nobody benefits in the long run if you use somebody else's mark. So don't use it. Use it very carefully. What I'm saying is, it should not be used in a way that you are transgressing the authority and rights of the other side. Ensure transparency in advertisement. So advertisement must not create any confusion, like I said, regarding the origin of goods or services. Monitor advert and keyword policies. Okay, use tools like Google Keyword Planner very responsibly, rather than just taking somebody else's trademark on the face of it and try to have a sponsored ad where you're trying to create a confusion among the minds of the consumers. For search engine operators, handle complaints promptly if there is any issue raised by any of the trademark owner. Please properly adjudicate it, where if there is any evidence that is shown and it amounts to an infringement, or it is it clearly shows that there is a goodwill and reputation of the trademark that is utilized by the competitor in a very dishonest way, you should take it down. Obviously it is now a direction, so search engines like Google and any other search engines, they should be very prompt in resolving such kind of disputes. So yeah, these are the key takeaways.
And thank you, Rahul, for joining me today, and thank you for throwing light on this otherwise complex topic, and thank you for simplifying it. So this brings us to the end of our episode, and thank you very much for joining us. Goodbye.
ANM ThinkPod, an initiative by ANM Global.